Good afternoon and welcome to another installment of our ongoing nonprofit leadership and engagement education series. I am Joanne Nazer, Manager of Nonprofit Leadership and Engagement at the Washington County Community Foundation. Thank you for joining us today to hear from our content expert about nonprofits as employers. This session is being recorded and will be posted along with a slide deck to the WCCF website under Grant Seekers Nonprofit Resources. During the presentation, we ask you to be mindful of others and keep yourselves muted. This will reduce background noise during the live session as well as the recording. If you have any questions during the presentation, you may enter those into the chat. Time permitting, we will have a question and answer at the end of the presentation. Follow-up questions after today's sessions may be emailed to the foundation at allocations@wccf.net. Our content expert for today's session is Rachel Lozosky, who's a partner with the law firm of Peacock Keller. We are certainly grateful for her time today. Rachel received a bachelor's degree from Washington and Jefferson College and her Juris Doctorate degree from the University of Pittsburgh. Her knowledge and experience have made her a sought-after and frequent speaker on an extensive array of employment topics. She has drafted company policies, guided nonprofits through employee discipline matters, and helped with termination matters as well. She's also worked on anti-discrimination law and personnel best practices. Rachel was named to the 2019 Pennsylvania Super Lawyers Rising Star list. She was elected president of the Pennsylvania School Board Solicitors Association in 2021. Outside the office, Rachel enjoys spending time with family and times outdoors gardening, swimming, and horseback riding. It is my great pleasure to introduce Rachel Lozosky.
Thank you very much, Joanne, and good afternoon to everyone. If there's any issue with the sound, if anyone is having difficulty hearing me, please enter that in the chat. Do a hand raise via Zoom if you can and let us know. Otherwise, I will trust that that is all working. I might be looking between two screens, and I really would prefer to be in the same room with all of you and making eye contact, but I can't do that. This is the most expeditious way to get this information out to everyone, so we're grateful for Zoom and to the Community Foundation for setting that up for us, and we'll do the best we can through Zoom today. So let's dive in. We have about 50 minutes. I'd like to leave some time at the end if possible for question and answer. So of course, you're speaking with an attorney, so the first thing I'll give you is a disclaimer that none of this is intended as specific individual legal advice, so please do seek out the advice of counsel as to your specific fact situations that you may face. So I want to start out just kind of framing some of the concepts that I've picked up over about 15 years of working with different nonprofits and also working in the public school system, which operates essentially like a large nonprofit corporation in many ways. So nonprofits as employers, you are definitely unique and you are also just like everyone else. So what does this mean? Well, you're unique in the sense that you need to work within the parameters and under the pressures of specific and often limited funding streams. And I don't need to tell all of you about how those pressures can come to bear. Now, you may attract employees who are driven by the organization's mission more than by personal gain, and that is also a good thing. And something I've observed working with nonprofits is that this may tempt you to apply the same kind of benevolent approach that you apply to those whom your nonprofit serves when you're working with your employees. So you may tend to give the benefit of the doubt or give some leeway, and that's not always a bad thing, but as we'll see today, there can be some traps in that approach, and at times that might not be in the best interest of the organization. You're certainly mission-oriented. You are by definition not profit-oriented, yet you still must run your organization as a business. Now, in what ways are you just like everyone else? You know, all of the for-profit corporations out there. Certainly, I've seen the challenges you face in attracting, retaining, managing, and unfortunately, when you need to part ways with personnel. And regardless of how mission-oriented your employees may be, you know, I think something we've all found working with people is that people are people. And human nature presents challenges in all aspects of personnel matters. And you have to handle these issues under much of the same general legal framework that applies to for-profit corporations. So the convergence of where you are unique and how you are just like everyone else is really what makes this so difficult for you as a nonprofit serving as an employer. Because again, you need to comply with these laws. You need to face the regulations, federal and state, that apply to most for-profit corporations. Most of those also apply to you. You face the same liability if you are not in compliance. And you're always trying, of course, to attract and retain high-quality personnel. And you're doing this with less of a budget than many for-profit corporations have. And you're trying to keep that focus on the mission. So you're often facing this difficult balancing act, which I've seen and I certainly appreciate, between trying to be in sound legal compliance, and you're trying to have strategies which are directed toward avoiding liability, but also avoiding this heavy-handed draconian approach that's going to drive away quality applicants and personnel. So how do you find that balance? And that balance is what I'm going to try to focus on today. And it may sound like the balance is tipped pretty far in the direction of compliance. That is my job. So, you know, to some extent, when all you have is a hammer, every problem is a nail. So I try to come at this, you know, from a human and a real life perspective as well. But really and truly, as a lawyer, my first interest today is to help you to understand and follow some recommended liability avoidance measures. And I think it helps to look at the why of those liability avoidance measures. So I'm going to set a foundation to help you understand what's at stake, you know, certainly what some of the key laws say, why it's important to follow them. That will just dovetail nicely into new developments and will lead into some best practices and hopefully help you to apply these issues in real life as well. Now, just another caveat, you are not going to be able to learn about, I'm not going to be able to cover today every single law, non-discrimination or otherwise, that will apply to you as an employer. So we're going to cover some that are key, and we'll try to get through that in the time that we have. And I'll just ask if anyone is not muted, if you could make sure that you are muted, that's very helpful. Thank you. So non-discrimination laws, we're going to spend a lot of time there today. That is not the only type of law that governs your practice as an employer, but wow, it really underpins a lot of the best practices that we recommend. It's an area where there is significant liability and where there is really an alphabet soup of laws that you need to look at. And like I said, we can't possibly cover them all in the time that we have, but we're going to focus on a number of anti-discrimination laws today. One of the most all-encompassing is the Pennsylvania Human Relations Act. And this applies to employers who employ 4 or more persons within PA. Now notice it says in industries affecting interstate commerce. That is broadly construed. Basically, if you have employees who ever pick up a phone and call another state, mail something, use the internet, most likely covers that, you know, going among states, it's pretty likely you're going to be covered. There are some exceptions you'll see for religious, fraternal organizations, but the exception really is an exception without a difference because the key anti-discrimination provisions still apply. So if you're digging down into the weeds and nuances on these, of course, you'll want to consult with counsel, but we're going to assume for today's purposes that if you employ 4 or more persons within the Commonwealth, you are covered by the HRA. And it's pretty straightforward. It's what you might assume. It prohibits discrimination in hiring or with respect to any terms and conditions of employment. So that's firing, hiring, promotions, demotions, raises, discipline, all of those kinds of things. And it protects individuals from discrimination on the basis of the categories you might expect: race, color, religious creed, ancestry, sex, national origin, handicap, and even the use of a guide dog. There are specific provisions that apply to healthcare providers. I'm not sure how many of those we have today with us. There is an anti-discrimination provision related to either refusing or agreeing to perform abortion or sterilization, or making any type of statement or attitude, manifesting an attitude related to those issues. Images under the HRA are similar to what you're going to see under a number of federal laws. Federal laws sometimes have additional penalties as well. I'm not going to read all of these to you, but I think it's important that you spend time looking at each of these. Certainly, if you review the slides afterwards, I've given you a sense of what is at stake. Bottom line matters to you. It matters to every business. You know, you're no different in the budgets in which you operate. And the bottom line is there is potential financial liability at stake for violating any of these rules, as well as potential orders to reinstate an employee who may have been problematic and you don't want back and may be coming back. On a federal level, Title VII of the Civil Rights Act encompasses a number of the same protected classes that are covered by the Pennsylvania HRA. So we have race, color, religion, sex, national origin. This applies to employers, again, affecting interstate commerce that employ 15 or more employees. And there's a formula for the working days and the calendar weeks in which that employment is covered. Title VII incorporates the Pregnancy Discrimination Act. And we're going to see some new developments in the area of pregnancy later. But for all employment-related purposes, basically under Title VII, you can't treat a pregnant employee any differently than you would treat a similarly situated employee, meaning someone who is similar in their ability or inability to work. So you can't say, we're not going to let you, do this particular project. You can't take this sort of parenting approach to them, that they're fragile. If they're a bit able to do it, you need to allow them to do it to the same extent that someone who's equally able could. But likewise, if they're unable to come to work, they have sick time, they have legitimate reasons that would apply to anyone else, you apply that to a pregnant employee as well. The Pennsylvania Human Relations Act also prohibits discrimination because of pregnancy and requires you to treat pregnancy as a disability in terms of granting reasonable accommodations. So this is where you may go beyond what you do for other employees. And we're going to get into that entire disability accommodations analysis a bit later. But just tuck away in your mind that would apply to individuals who are disabled based on pregnancy as well. A laundry list of damages for violating Title VII. It's about, again, your bottom line. So you'll want to make sure you know what's at stake there as well. Another important anti-discrimination law at the federal level is the Age Discrimination in Employment Act. I was somewhat disappointed to notice in recent years that I am now covered because it's individuals as soon as you reach 40 are covered by this law. Pennsylvania's HRA also, in its age discrimination protections, protects individuals who are age 40 and over. The federal law applies to those with 20 or more employees, but again, Pennsylvania is going to pick that up if you only employ 4. Now, something interesting about age discrimination, and this goes, everything I'm going to say about age is falling under federal and state. Generally, there's extensive overlap under both of those areas. So you can assume everything I'm talking about is likely going to apply to you, again, if you meet that state minimum of 4 employees. But something a lot of people don't know and are surprised to know about age discrimination law is that there can even be a cause of action for discrimination among folks who are in the protected class. So if someone who is 40 or over but is younger than another employee in that protected class, so the 40-year-old is treated more favorably than the 60-year-old, that too is a potential cause of action. There are damages under the ADEA, more than just lost wages. There's back pay at stake that takes into account lost benefits, bonuses, etc. In most of these statutes, you're looking at paying the plaintiff's attorney's fees and costs if they prevail. So that is obviously substantial. And again, that possible equitable relief of someone being ordered back to work that you may have had legitimate reasons for terminating, but if it's found to be discriminatory, whether that was your intent or not, which we'll get into, you may be faced with rehiring that individual by order of court. So that will lead us to a few best practices. We'll duck out of the laws for just a minute because it's a good place to start to talk about avoiding successful claims alleging discrimination. It is almost impossible to avoid a lawsuit. People can sue for anything. The goal is always to get that suit stopped as soon as in the process as possible. So one of the overarching recommendations always is that you create and uniformly apply policies and procedures that are objective, that are clear, and that address all aspects of personnel administration from hire to departure. And one issue that I'm certain if you've worked in HR, you've heard this preached before, and I will preach it in every presentation that I give: thoroughly document the reasons for the action taken and the way in which it complies with policies and procedures. And I think it's helpful to look at, in general, what a cause of action under any of these statutes would look like. Now, again, there will be some nuances, but this is the overall framework that you need to be aware of. And not that you're going to be personally trying the case, but I think it helps you to see where these objective and uniform policies and procedures really become so important. So if I'm a complainant and I am suing you as my employer or my former employer, and I'm alleging that you discriminated against me, and let's just make it simple and say that I'm alleging it was on the basis of my gender, so I'm female. So all that I need to prove just to get my foot in the door and have enough of a case that now the court is going to entertain it and see where it's going to go is I need to show that I'm a member of a protected class. And by the way, there's no such thing as reverse discrimination. So when we're talking about sex, for example, the protected class is sex. So a man has the same potential to bring a claim saying that he was adversely treated as I would have. People use that term reverse discrimination because they tend to think that certain groups like women are historically disenfranchised. There is no reverse discrimination. Sex covers both sexes, race covers all races, and discrimination allegations can go in any direction among those classes. So I need to show that I was a member of the protected class, so I have a gender-related issue. I was qualified to gain that position or gain that raise or whatever it might be, and that I was denied, and that a man, because this would be the differently situated person in this instance, was treated more favorably. That's all that I need to show just to get my foot in the door. So then the burden shifts to you as my employer or my former employer to show, no, we had a legitimate non-discriminatory reason. It wasn't because you're a woman, Rachel. It's because your performance was poor. You were late to work every day. You didn't follow rules, etc. But even once you establish that, I can still win this claim if I can establish that that was merely a pretext. And how do I do that? Well, this is where following procedures and documentation is so important. So if, for example, you claim that I've been late to work consistently, but you've not addressed that with me, there's no record. You claim that you did, but you don't have it in writing. Or when you terminated me, you were trying to be nice, and you were trying to be kind, and you said it's just not working out, but you didn't give the reason. Now, if the first time you're mentioning my tardiness is in the lawsuit, that starts to look like a pretext. And if you can't back it up and show that it was something other than a pretext, you very well may have liability here. So what I like to say is that lawsuits and liability love a vacuum. Okay, so if legitimate non-discriminatory reasons are lacking, if you didn't follow your policy, if you don't have a good objective policy, if all you have is your word against theirs and no documentation, that is a vacuum in which I, as the claimant, can fill the void and say, you know, without absent any other factor, it certainly looks bad on the face. Remember, all you need to do to have a prima facie case, so the man was treated more favorably. You don't have anything to fill the void. It looks discriminatory. So back to some best practices with all of that in mind. Let's start specifically from start to finish. So with hiring, the first thing that you are always recommended to do is set objective, qualitative. So if you can rank, if you can use a number, a score, to be as objective as possible, set those objective qualitative criteria for scoring candidates in both the application and interview process. And then any policy is only as good as the extent to which you follow it. So hire based on the same. Job descriptions are key. We're going to see that in a couple of other areas we discussed today. You want to make sure you carefully think through what are the essential functions of the position and the qualifications on any level, education, skills, physical requirements, which tie into ADA issues, as well as when people tell you they need time off and you need a doctor's statement as to whether they can work or not. Don't neglect, no matter how white collar you may assume your positions to be, there are physical requirements in any position, even if it's simply ability to sit or stand for long periods of time. So don't neglect that as well. I recommend that you avoid terms like relevant experience without stating what it actually is. The best thing to do is, again, explain that experience and those qualifications. Do not ask questions or pursue discussion, even if the interviewee raises it, about any matters that are not relevant to the position. The safest thing to do, and I understand we are all humans, we want to bond and talk about our activities outside of work and get a sense of who you are as a human. Just be aware that anytime you open that door and say, tell me about yourself, if in their discussion, this falls under, sadly, the no good deed may go unpunished. Sometimes they go unpunished, but not often. So if in that casual conversation, I raise, for example, the fact that I'm Catholic because I bring up, I teach CCD on the weekends and I don't get the job, I could very easily, take your benevolent time spent just chatting with me and turn it around and say, I revealed my religion. And the person who was hired is of a different religion. And, is that alone enough? Well, maybe not. But, if you don't have objective scoring procedures, if you don't have, again, enough things to fill in that vacuum, the fact that you learned something about my religion or my familial status or anything of that nature can be used against you in the future. We have a list that the employment lawyers prepared at our own firm that we use in interviews, and it says it's none of your business. And it reminds the non-employment lawyers of questions they should not ask, but generally staying away from the open-ended questions is helpful. On the flip side, having a standard list of questions is also helpful because this, again, keeps the process as objective as possible. So we're not getting into different types of questions that are alleged to be easier or more difficult for different individuals. And particularly nonprofits, you often have an interplay between the executive director, board of directors, what their roles are in all aspects of employment work. So it's helpful to delineate how that process works in hiring. There is such a thing as a bona fide occupational qualification. There are some jobs for which gender, for example, may actually be a legally permitted basis for hiring. That is a difficult area. very industry specific. So I would certainly recommend you consult with counsel before you would rely on that. Okay, another way, this is starting to look like every way you could possibly be sued, but again, this is my job to some degree. So even if you have neutral policies or procedures, if as applied, they could have a disparate and adverse impact on some aspect of a protected class, so men versus women, people with families and children, if those policies are not justified by business necessity and you can't be prepared to demonstrate that, those policies could also be found to be discriminatory. So just some examples, if you have very broad policies without exceptions built in, this goes for really any type of policy that you make very absolute, very black and white, very all-encompassing, can get you into trouble in a variety of ways with respect to discrimination if you don't carve out exceptions for religion, for disability-based accommodations, which we will discuss. That can be a disparate impact area. I'm going to use an example about a policy that would assign points and evaluations that would judge you based on your willingness to attend work events after hours. That's something that often comes into play with the type of work that nonprofits do. Could this have a disparate impact? The first category I would see would be familial status, people with young children. Does this mean you can never require people to do something that is networking and is important to the nonprofit? No, but let's see how that plays out. So when we're talking about disparate impact, the employer has to establish that there is a legitimate business purpose which is necessary, and you can't achieve that by any less discriminatory means. So let's look at the example of requiring an employee to participate in after-hours marketing activities. Again, the more careful you are about making this related to the essential functions of that position, the better off you're going to be. I believe you could demonstrate that it is a business necessity that couldn't be accomplished in any other way for your marketing director, if you have one, or your community outreach liaison, or whatever the position might be, that it would be business justified to have that person available and to know that the job is not 9 to 5 and that they need to be at evening events, sometimes in addition to their daytime job. It's not a given that it would be flexible. As long as you can show that it's necessary for that position and there really is not another way that you could set up that requirement. Now, making that a requirement of your bookkeeper is much less likely to be defensible. And I think you can see why. Again, the necessity to the position. So this brings us into some accommodation issues, religious and disability. This is not just a matter of building exceptions into your policy, although that is important. If you have any policy that, for example, a dress code, anywhere that would implicate exceptions need to be made in accordance with law, you need to do that. But I recommend also that you have, and the EEOC recommends that you have a separate policy that informs employees of their rights to accommodations, how to request them, how they're granted, essentially a policy that deals with disability-based accommodations and religious-based. Because again, if you employ 4 or more, at least the state law and possibly also the federal law, which essentially overlap and are the same in these areas, are going to apply. I'm sure you've all at least heard of the Americans with Disabilities Act, the ADA. That applies to folks who employ 20 or more, but again, the Human Relations Act is going to pick you up with the same requirements if you employ 4 or more. You cannot discriminate against a qualified individual in terms of hiring or any term or condition of employment based on disability. And so a qualified individual is someone who can do the job either without or with a reasonable accommodation. And disability encompasses a lot. You can see the definition. I won't take the time to read to you, but it is broad and all-encompassing of many, many conditions. So again, if they can perform the duties with or without a reasonable accommodation, they are qualified. Therefore, you need to offer reasonable accommodations. Now, an accommodation only needs to be made to allow an individual to perform the essential functions of the position. You as the employer define what those are, but you still have potential liability if you're putting things that are tangential and not really at the heart of the essence of the position into the description and calling them essential, because that's possibly screening someone out with a disability for something that isn't key to the job. So it goes back to, you want to think carefully about how you structure your job description. And if someone says that they need an accommodation, first question, is it to perform an essential function? You look at that job description, and if it is essential, then can we provide an accommodation that is reasonable? You don't have to give the preferred accommodation, just one that is reasonable. And the key here is what is called the interactive process. So you talk with the employee to interact and decide what might be a reasonable accommodation. It is not reasonable if it presents an undue hardship to the business, to the nonprofit. How that's determined, it's case by case. A court would look at things like your size, your financial resources. Cost alone is not a sufficient factor. This is an area where if you're having doubt and you're struggling, an attorney can certainly help you through that interactive process. Generally, an employee has to ask for an accommodation. You don't need to offer it, but you see written here some circumstances where you would need to offer it. Legally, you would be required to do that. If you already know the individual is disabled, you know or have reason to know that they're having problems in the workplace because of that disability, and the disability keeps them from being able to ask you for the accommodation. Drugs and alcohol, unfortunately, become an issue, and questions arise. How far do we have to go in accommodating these issues? You can certainly prohibit illegal use of drugs and any use of alcohol in the workplace. You can hold your employees to the same standard that would apply if drugs or alcohol were not an issue. Even if they tell you that they have a condition of addiction, that does not need to be an excuse and shouldn't be an excuse for not complying with policy. Where a reasonable accommodation may come in would be time off from work to attend rehabilitation. That can be tricky, time case by case. Again, is it reasonable to the business? Case by case analysis. Note that I am not even touching medical marijuana as a topic today. That is detailed, and that's another seminar for another day. Religious accommodations, there has been a key development from the United States Supreme Court in this area this year, so we'll take some time on that. Areas where this could arise are with respect to work schedules, dress, hair and grooming. Know that the EEOC and likely the state would take a broad approach. EEOC, by the way, is the Federal Equal Employment Opportunity Commission. So legally, a broad approach is taken as to what is a religion. You as an employer don't get to look behind someone's sincerely held belief and say, that's not a religion I've heard of, that's not an established religion. Basically, a sincerely held belief that rises to the level of a religion is protected. Now, if you have an objective basis for questioning that, you would be justified in requesting additional information. So this wouldn't necessarily be religious, but a quick example that I use is, if someone claims that they're a vegetarian, but you have seen them eating hamburgers, several times a week, that's more than you just saying that religion sounds fishy to me. So that's not enough to question it. But if you've seen them eating that hamburger, that's an objective basis to look for a little more information before you would make an accommodation. You need to thoroughly consider any accommodation that might be possible. Very similar to, at least on its face, similar to the wording that we hear in ADA. For religious accommodations, you don't need to accommodate if an undue hardship would result. Now, here is where the law has developed within the past year. A 2023 Supreme Court case that was decided this past spring, Groff v. DeJoy, changed a bit the standard of what an undue hardship is in the religious accommodation context. So previously, if there was anything more than a de minimis cost, so basically any appreciable cost at all to the employer, that was considered an undue hardship and you did not have to make the accommodation. Groff has now broadened this into an undue hardship in the which is substantial in the overall context of an employer's business, taking into account all relevant factors. And you can see the rest of that analysis there. I have not yet encountered a situation where I've needed to interpret this case for a client. To my knowledge, there's not precedent in our Third Circuit yet here, but I didn't check that immediately before this presentation, so it's possible. This is a tricky analysis, as you can see. The Supreme Court uses a lot of words that sound like they might make sense on their face, but they are fact-specific in application. So with this being a new standard and the law developing under this, I would ask you to consult with counsel on that issue. Again, I'm not aware of anything in the last extremely recent time frame that's come out on that case. We have some new federal statutes addressing pregnant workers and workers who have recently given birth, so we'll turn to those. June 27th of 2023, the Pregnant Workers Fairness Act, which applies to employers with at least 15 employees, took effect. That's a federal law. So this is interesting. It sounds very similar to what you're required to do under the PA Human Relations Act, which is to accommodate pregnant workers. But remember that under that law, you need to make an accommodation if they have a disability related to pregnancy. Under the Pregnant Workers Fairness Act, it is for any known limitation related to pregnancy for which you need to make an accommodation. So this could be morning sickness that occurs only occasionally. This could be high blood pressure. This could be potentially extreme fatigue. So things that may not meet that ADA definition, you nonetheless, if you are covered by the PWFA, need to engage in that same ADA interactive process with an eye towards seeing if you can reach a reasonable accommodation for a condition related to pregnancy that interferes with the ability to perform the essential functions of the job. A couple of specifics just to highlight: you cannot place an employee on leave if she does not want leave, and if another accommodation can be provided. Generally, you're going to have the same damages and liability as you would see under their non-discrimination law. So this is a little tricky. Another federal statute, which took effect in part in December and then completely in April of this year, the PUMP Act. This applies to employers of all sizes who are covered by the federal Fair Labor Standards Law. Now, I will tell you that your nonprofit entity may not be covered overall by the FLSA. That does not mean, don't you just love the law? That does not mean that you are not covered by the FLSA's requirements related to overtime pay and minimum wage and the comparable state laws, which we will get to. There are other ways that you are covered, including if your employees individually fall under those laws. You, however, as an entity, may not be covered overall by the FLSA, which means that you therefore would not be covered by PUMP. In order to be covered overall as an entity by the FLSA, you need to do business of at least $500,000 worth of revenue in a year. And that's not about providing your charitable services. That is a business type arm of your organization. So if you have a gift shop, that's the prime example, and it does at least $500,000 worth of business a year, you're covered by the federal Fair Labor Standards Law. If not, you're not, which means you're also not covered by PUMP. And that may be a fair amount of you present for this webinar. Now, your individual employees, here's where the catch is. If they have any interaction with interstate commerce, again, picking up the phone state to state, shipping things, generally we take the presumption that all individuals in a business are covered. So they come under the wage and hour laws of FLSA, and we'll get to those in a bit. But again, as an entity, if you're not covered, you're likely not covered by PUMP. If you are covered, basically this law deals with providing breaks for pumping breast milk and providing a private place other than a bathroom for an employee to do so. There are some exemptions for employers with fewer than 50 employees. But those are the highlights. And again, not a ton of time to spend on that because many of you may not be covered. Something just important to know is that, again, Pregnant Workers Fairness and PUMP, those are in addition to your overall non-discrimination against pregnant individuals under federal and state law. Liability can overlap. So just know that, when we talk about what's at stake, you're looking at potentially 4 statutes now, federal, state, new pregnant workers, and potentially PUMP. So that takes us back. I know that's a whirlwind of some updates. And I want to wrap up in 10 or 15 minutes or so for questions. So back to some recommended practices for employment. So we've talked about hiring now during the course of employment. Again, nothing new under the sun here. You want to develop and follow uniform policies. When you have an issue with an employee, this is not the place for balancing, the softer side of nonprofit work. You need to be honest. Liability loves a vacuum. And also a phrase I've picked up from a number of sources over the years is that unclear is unkind. You think you're being kind by letting that performance issue go, but how fair is it? How kind is it to an employee to not tell them, not give them a chance to correct, and then hit them with a terrible evaluation at the end of the year and or be prepared to fire them? It's not kind, and it is an area of potential liability. Job descriptions, we talked about the necessity of being clear as to what the essential functions really are. And if there is a contract that governs employment of an individual, then you need to follow that throughout employment. Then on the other end of the spectrum, termination. Again, I mentioned earlier that you need to be clear and honest in your reasons, consistent with what you tell them verbally and in writing. Follow any policies. It is possible that some of your employees may have individual contracts. And you may have heard of the phrase employee at will. So an employee at will simply means an individual who does not have a contract. So they can be fired for any reason or no reason, as long as it's not an unlawful reason. Unlawful comes back to all of the things we've talked about before and then some. So it doesn't mean you can do what you want for any reason at any time. It just means there are no contractual protections. If there is an employment contract, it may prescribe the way in which termination works, benefits at termination, benefits that or penalties that apply based on the reason for termination. So certainly you want to check, particularly for those folks who have been with you for a long time and no one remembers exactly if there was a contract. You want to try to look for that and make sure you know what it says if you're going into termination. Always recommend that legal counsel is involved when you are offering a severance agreement. There are times when you may want to offer an agreement and give someone a benefit to get their actual agreement to leave as opposed to fire them. You want to make sure that you are getting something that is fair in return, that you are being released to the full extent of the law for any claims they could make against you, and even talk through the strategy. Is it even worth it to offer this? Could that backfire and cause an employee to maybe bring a lawsuit that they hadn't thought of? So there's a lot to consider when you're looking at severance agreements. One of the things to consider, we talked about the age discrimination law. I had to laugh when I turned 40 a couple of years ago that they think we need all of these protections now. I guess our minds aren't functioning as well as they once did. I disagree with that, but there is specific language that needs to go into a severance agreement for individuals 40 or older. There's a certain time frame, at least 21 days, that they have to review it. So if you're dealing with a worker in that protected class, you have to know that. If you are presenting some type of voluntary or involuntary termination program, some type of exit incentive or forcing them out, if you're dealing with at least 2 employees of any age, at least 2 employees who are over 40, You need to have specific language in that circumstance as well. And then there is the WARN Act for larger group layoffs that requires very specific language. So again, just in the context of a severance agreement, a lot of things to consider. Some new developments that you need to consider with respect to severance agreements and beyond. The National Labor Relations Board has been very active since about February of this past year in issuing some decisions that impact a number of documents, contracts, and policies in particular. The National Labor Relations Act covers all employees who are not supervisory or managerial. It does not cover only unionized employees. It's very broad in its reach. The theory is that anyone who is not a manager or a supervisor or an owner has the right to talk about, to bargain, to address the terms and conditions of their employment with their employer at any time. So the National Labor Relations Board is always looking for things that chill employees' rights in that regard. So where they focus this year are several areas. One of those areas is in non-disparagement and confidentiality clauses, which you find in severance agreements. If they are overbroad, they will be considered to be violations of the National Labor Relations Act. So in this decision, which and unfortunately says 2021, I'll have to fix that. That was 2023 of this year, McLaren-McComb. Confidentiality agreements and non-disparagement clauses were looked at, and the court looked at the specific language of two of these provisions, one of each, related to a certain employer. So they found that a confidentiality agreement worded as you see here that says you, employer, can't talk about this severance agreement with anyone other than your closest inner circle. That has a chilling effect on folks' rights under the National Labor Relations Act and cannot be included in a severance. The board also found that in McLaren-McComb, the same decision found that a non-disparagement clause, not confidentiality in general, so not confidentiality of the employer's trade secrets or anything like that, but non-disparagement, I put the language in bold from this particular provision that says the employee agrees not to say anything that's damaging to the employer's profile, that would harm their image in the public, that also would violate the National Labor Relations Act because it chills an employee's ability to complain, even on the way out the door, about the terms and conditions of their employment. McLaren-McComb also held that even the offering of a severance agreement, even if the employee doesn't ultimately sign it, the offering of a severance agreement with one of these prohibited non-disparagement or confidentiality clauses would violate the National Labor Relations Act. Now, a number of things are up in the air after McLaren-McComb. This decision, again, is only in the context of the NLRB's enforcement. So would courts adopt this reasoning to invalidate similar clauses? Just checked this a few days ago, nothing yet in our controlling jurisdiction, at least. Could this decision be applied to agreements that were already signed prior to this decision? Possibly, but there would be a 6-month statute of limitations from the date the agreement was signed. That's part of the act in general. Would this decision, which covers now severance agreements, be expanded to cover employment agreements? I would think possibly yes, but that's not clear. Would the decision be expanded to apply agreements pertaining to supervisory employees in as much as it stops them from talking about conditions that would impact non-supervisory employees? We don't know that either. Again, the law just needs time to develop and interpret these issues. I'll skip the severability piece because basically if you have a good clause that says if anything is unlawful, the rest of the agreement is still lawful. If you had someone write a good agreement for you with that clause, then putting these clauses alone in won't damage the effectiveness of the entire agreement. And potentially there are still confidentiality and non-disparagement clauses that could be upheld. They certainly couldn't be those that sound like the ones that were struck in McLaren-McComb, and we would have to see what those might be. Speaking of the NLRA and non-disparagement, you want to be careful with any of your policies. Now, this is beyond agreements, but this is still under the purview of the National Labor Relations Board. Any policies that chill an employee's ability to raise complaints and concerns, certainly social media. There is a good policy on the NLRB's website that they have upheld in a case involving Walmart several years ago that they have given their stamp of approval on, because social media can definitely be a pitfall when you're saying don't be out in public saying things against our organization. That can be found to be non-disparagement that violates the NLRA. And certainly you always want to ensure that you are not retaliating against employees for asserting any of their rights, either under the NLRA or any non-discrimination laws in general. And this brings us back to best practices and new developments for employment. The NLRB also issued a decision just in August of 2023 dealing with policies not like those I just mentioned that explicitly say you can't complain about your employer, but policies that may be neutral on their face, but nonetheless, like the disparate impact discrimination we talked about, nonetheless can have the impact on an employee of chilling their rights to argue about the terms and conditions of their employment. So if this is going to be an investigation by the NLRB, it's back to that, looking at it on its face. And then you have the option to argue that this does not, in fact, chill an employee's ability to argue about the terms of their employment, that it advances a legitimate and substantial business interest, and you can't do it in any more narrowly tailored way. Bottom line is you're going to need to be careful, review existing policies, see if there is something that a reasonable employee, and the NLRB takes the approach of an employee and the fact that your average employee is looking to comply with rules. I sometimes would dispute that, but they're looking to follow the rules. So they're going to try to, as an employee, you're going to look at it as carefully as possible. So even these broad rules that sound neutral, as an employee, if I'm going to carefully follow them to try not to get in trouble, that could chill my right to address the terms of my employment. And so we need to be careful that those things that look neutral couldn't be interpreted that way. The rules that were specifically addressed in this case from the NLRB governed personal conduct, conflicts of interest, and confidentiality, but the board did not get into the specifics of those policies at all because it just issued a ruling saying essentially any policy of this nature on its face, neutral, that in its application impacts employees adversely, could be unlawful. Bounce that back to the administrative law judge to look at these policies specifically. So again, one of those areas where they've given us rules without a lot of specifics, and you just probably should stay in touch with counsel and watch this as it develops. Non-competes and non-solicitations, another major area from the Labor Relations Board this year. Non-competes and non-solicitations in general, that other courts outside of the NLRB setting would interpret, need to be carefully tailored, not overly broad with respect to the geographic limitation in which we say someone can't compete, the time limitation, all of that. The NLRB goes even a little farther and says that, many of these agreements are going to stop someone again from asserting their employment rights, because if you can't compete when you leave this job, you are less likely to negotiate for better terms while you're working. Non-solicitation is specifically about past employees soliciting coworkers go and work for competitors. So generally, the NLRB is frowning on these types of provisions now as a whole, and they're saying that they might only be upheld if they restrict you after working for this employer from owning another business, but certainly not just from working in one. And maybe if they restrict true independent contractor relationships, but that's about it. So unresolved issues, again, will other courts outside of the Labor Relations Board look at this reasoning and invalidate even more non-competes and non-solicitations? We don't know. Will it be applied retroactively? We also don't know. In theory, something more narrowly tailored might pass muster, but it seems that the ban is getting broader and broader, certainly with the NLRB and potentially in other courts as well. So what's the big deal if you violate the National Labor Relations Act? Well, you'll go through a difficult investigation and hearing. You might be ordered to, again, take that employee back with or without back pay. There can be substantial fines and penalties. You may be directed to rewrite rules and policies, even those beyond the subject of the complaint. And we have seen that even if the NLRB gives their blessing once on a policy, they may change their mind again in the future. So basically, you don't want to be on their radar. Okay, about 2 minutes before I get into questions, and I do want to leave a little time for that, but I promised I would give you some balance, right? So it sounds like we're really coming down hard on the avoiding liability side of things. Just remember, in fairness to the employees, that these rules, again, are also intended to be clear, and in that way to be kind and help these employees to fulfill the mission orientation of the nonprofit. Where are some areas where you can give a few perks to employees? Potentially in flexibility in hours and flexibility in location of work. Those are two areas that employees are looking for a lot today. Be very careful with this idea of flex time. This could be an entirely other topic. Remember that I said for purposes of wage and hour laws, almost all of your employees, you can assume that your employees are going to be covered by federal and state wage and hour laws. So you need to be sure that you have carefully classified your employees as either exempt or non-exempt. Non-exempt means that they are entitled to overtime. You cannot force someone to take compensatory time in lieu of paying them overtime. If they are entitled to overtime by law, they need to receive that. That's different than a flex schedule. So if they've earned the overtime, they need to be paid that. You have potential serious liability from the under the Fair Labor Standards Act and Department of Labor investigations if you misclassify someone who should be entitled to overtime and you call them exempt and you do not give them the overtime that they need. I have given you in the slides, and you can certainly go through and look at those, the seriousness of the potential penalties, and then the tests for what makes someone exempt, what takes them out of the realm of being entitled to overtime. This is the same generally under federal and state law. There are generally 3 big exemptions: executive, administrative, and professional. There are also some that are position specific. So you'll want to look at those, and certainly you can pull out the regs and most advisably consult counsel when you're trying to determine this. You want to be careful if you're giving flexibility to salaried, to true exempt employees, those who are not entitled to overtime, because if they are truly professional, administrative, managerial, they're truly not hourly, they don't get overtime, then you don't want to turn around when you're giving flex time and start nickel and diming and calculate hour per hour. Okay, you came to this event last night, so you get 1 hour late today, because the more that you do that, if the employee can prove that you did it, believe it or not, that can put them back in the category of the law and the Department of Labor seeing that employee as hourly and thus entitled to overtime. So yes, you can be nice in flex time to an extent, but as always, there are rules that apply here. And that can be an entire other seminar on wage and hour that you need to be aware of. And finally, flexibility in work location. Is the trend still trending toward remote work? It's hard to say. In some industries, yes, some no. If you're going to offer this as a positive to your employees, as with everything else, be fair and consistent in how you apply remote work and how you allow that privilege. Make it clear that it's not a right, except in cases where it may be a reasonable accommodation for a disability or pregnancy. Define what remote working means and be very clear about the rules that apply, and then again follow those rules. Address things like confidentiality. State what your expectations are. You know, are your remote workers truly to keep the same rigid hours they would keep at the office? Are they allowed some flexibility for childcare, other family duties, that kinds of thing? Are you okay with them meeting with clients or third parties via Zoom? How do you enforce a dress code or appropriate behavior in that way? All things to consider when you're trying to balance some perks and some fairness to employees in flexible work locations. Okay, that was a whirlwind. Again, you can certainly rewatch, look at the slides and try to digest, and we have maybe a little bit of time for questions that you may have at this point. And you can certainly email questions to WCCF as well if they hit you as you digest it all.
Sorry, I was muted.
Yeah.
Thank you, Rachel, so much for your talk, your presentation. It was so thoughtful, and it's given, I think, everyone food for thought, and we just appreciate your time. I have a question. Are there any restrictions relating to 1099 employees?
Yes. Okay. So independent contractors. So the first thing is, it gets very circular. People tend to think if someone is paid by a 1099 that they are necessarily by definition an independent contractor. So the first thing you always want to do is look behind that and make sure that they are truly independent contractors by virtue of the level of control that the business has over them and many other factors. There's a whole analysis. So the first thing I'd advise is make sure they're a true independent contractor, because just because you pay them by 1099 doesn't mean legally they are. Secondly, the anti-discrimination rules generally also apply to independent contractors. There are some nuances within that, but you generally want to apply that as well. As far as labor and hour laws, they're not true employees. But you just need to look at that kind of case by case. There are some laws that differ for them. And that's a whole other discussion, really, to get into some of those specifics.
There's another question, Rachel. And do you recommend the senior executive have a contract in general?
Yeah, in general, it really depends on the objective of the organization. I recommend yes, but when I talk about your objective, what I mean is, do you want to have more flexibility or less in terms of your ability to part ways with that person if it doesn't work? And believe it or not, you can still, this gets tricky, and I didn't want to get into this too much earlier, but you can still make someone an employee at will and have a contract with them that sets forth all kinds of things about your expectations and other terms, and you can still say within it, we can let you go at any time for any reason. So that's the piece I think you want to really think about, the goal, if you want more flexibility or not in that regard. But I think overall, with something as high level as an executive director, it's a good idea to have a contract. And if you don't, you want to have a very, very clear job description. But a contract can also allow you things like, consequences for not meeting goals, raises at certain benchmarks. So something at that high level, I do think it's a good idea.
Another question is, how are compensated board members treated?
Compensated board members. That is not something I've looked at. I will be perfectly honest. That's a different area. I was looking strictly at employees. And I imagine that there are more specifics under PA nonprofit corporation law, which is definitely something that could be looked into, but I was looking only at employees for purposes of this.
And I imagine most of our nonprofit boards members are not compensated.
That was my assumption.
Yes. Yeah. Right. Well, If there are no other questions right now, feel free to send them also to allocations@wccf.net. Want to thank you again, Rachel. We appreciate your time and valuable insights into nonprofit as employers. The next session in our nonprofit leadership and engagement series will be on Tuesday, December 5th at noon again, and will focus on compilations, reviews, and audits. What is appropriate for your organization? It will be presented by Gary Kissinger, who is a CPA with Palermo Kissinger and Associates. Look for a registration e-blast in the coming weeks. Thank you again for participating in this session, and I hope you have a wonderful day.